Absolutely. That's a very good question. Sometimes we have people, whether they're just very small without a lot of lung capacity, older smokers, some type of illness, head cough, and they can't blow into that machine. You know, the cop might think that they're trying not to blow into it, not believing whatever excuse they have, and then say, hey, you need to do a blood test. Well, you tell an officer that you're afraid of needles, or maybe you're a hemophiliac, or for whatever reason it happens, and you don't do either test, you're looking at a refusal. One of the defenses that we have to these refusal cases is called officer-induced confusion, and sometimes people will ask questions. A lot of times when people are from other states where they don't always have to do a test, but you do in California after an arrest. They might say, I want to talk to my lawyer, and the officer is supposed to tell them, well, you don't get to talk to your lawyer in regards to whether or not you do a test. It's not you do that. So that can, sometimes you have confusion because an officer may have read Miranda rights, and if that's happened, the officer may end up confusing someone. Someone may say, hey, I thought you said I had the right to an attorney, now you're saying I don't. For this, and just get enough so that it was confused. There is some new case law, and it basically says that if someone does seem like they're confused, that the officer doesn't just read verbatim the implied consent warning and what happens, if you don't take this test, losing your license for a year or more. They need to explain it in a little more detail. Whether that works or not, it did in one case because an appellate department granted that appeal, and it's still, though, you're rolling the dice if you think that that's going to work every time, or a variety of that's going to work. So you got to be very, very careful with the refusal cases because they are so hard to win. I can tell you other situations where someone allegedly refused, and the results were not a refusal, but it's very, very tough. I had a situation where a client was so out of it, so sick, they were thrown up in the jail. We had video, they did not understand, they could not comprehend what the officer was saying. Now, most of the time, that defense does not work. In this one case I had, it was a San Mateo County case. We got the DMV to determine that it was not a refusal based on video, based on officer testimony. In fact, the officer came in and said, I wasn't really sure if they understood what I was saying. Although I've seen that not work more often. So you've got to be careful. You really do with this refusal case. Because, again, we can and we do sometimes win the refusals, but they are the toughest cases to win.